Corporate Integrity Agreements, or CIAs. These are agreements between healthcare providers and the Office of Inspector General in the Department of Health and Human Services, which we will be referring to as the OIG. These agreements focus on future compliance of providers and practitioners that are participating in the programs. Here is a list of the topics we hope to address in this program this afternoon. There are certain acronyms that we will be referring to, and I just want to draw them to your attention. First is obviously CIA for Corporate Integrity Agreement. The next is IRO for Independent Review Organization. And third is OIG for Office of Inspector General. Let's start our discussion. As you all know, in recent years, increased attention has been given to identifying and addressing healthcare fraud and abuse. This is especially true with respect to the two primary government programs, Medicare and Medicaid. Last year, the Medicare payment error rate was estimated to be over 10%. Fraud and abuse cases may be addressed and resolved through various legal remedies. They include criminal prosecution, which may result in either a criminal conviction or plea agreement and resulting imprisonment, probation, and fines. Civil action, such as under the Federal False Claims Act, which may result in either a monetary judgment or settlement of the case. Recoupment or recovery of identified federal health care program overpayments, or program exclusion, where an individual or entity is barred from participation in federal health care programs. Increasingly, federal enforcement and payer agencies are coordinating their actions and developing a global resolution of a case, resolving criminal, civil, and administrative actions, and often resulting in the development and execution of a Corporate Integrity Agreement, or CIA. It is important to know what the key federal enforcement agencies are, so let me briefly summarize them. The federal government's primary enforcement agency is the U.S. Department of Justice. It's comprised of Maine Department of Justice and U.S. Attorney's offices throughout the various states. It acts as the primary attorney for the federal government and has the authority to bring both criminal and civil court actions. In addition, it conducts negotiations and enters into settlements on behalf of the federal government. With respect to the Medicare and Medicaid programs administered by HHS, the Office of Inspector General is charged with conducting investigations, audits, and reviews relating to the programs and identifying fraud, waste, and abuse in the programs. If the OIG believes that there are violations of law, it is authorized to refer a case to the Department of Justice for review and enforcement action. On behalf of HHS, it participates with the Department of Justice in the negotiation and settlement of fraud and abuse cases. Further, it is often charged with monitoring future compliance of a healthcare provider or practitioner that has entered into a settlement. It does this through the previously referenced CIA. Another participant in efforts to maintain the integrity of the Medicare and Medicaid programs is the Centers for Medicare and Medicaid Services, or CMS. And as the administrator of the Medicare and Medicaid programs, it issues regulations and instructions relating to administration of the programs, including coverage and payment standards. In addition, it oversees both payment and integrity contractors that are charged with reviewing and paying claims and identifying fraud, waste, and abuse in the Medicare program. Where potential violations of law are identified, CMS or its contractors may refer a case to either the OIG or DOJ for further investigation or audit and appropriate legal action. And finally, at the state level, most states have a Medicaid Fraud Control Unit, which is often a part of the Attorney General's office and is charged with investigating and taking enforcement action under state law for misconduct involving the Medicaid program. I would like to now discuss with you the authorities of the Office of Inspector General in HHS. The OIG was established in 1976 as the first Inspector General in the federal government and was authorized to conduct audits, investigations, and reviews related to HHS programs, including Medicare and Medicaid. It has four primary divisions: the Office of Investigations, the Office of Audit Services, the Office of Evaluations and Inspections, and the Office of Counsel to the Inspector General. Each of these offices has a role with respect to monitoring the administration and payments made under the Medicare and Medicare programs. As with other agencies, OIG has designated offices to conduct its investigations, its audits, and its program reviews. Unusual for a federal agency, the OIG also has a large staff of attorneys in its Office of Counsel to the Inspector General, OSIG, which is staffed by over 70 attorneys and paralegals, located both in Washington, D.C. and various regional offices. This legal office has the responsibility for working in close coordination with DOJ and CMS and undertaking enforcement actions involving Medicare and Medicaid. It takes an active role with the Department of Justice and CMS in the negotiation and settlement of cases, and where there is a global resolution of a case involving the resolution of criminal, civil, and administrative actions, it often develops and enters into a corporate integrity agreement. Further, if a CIA is developed and executed, the OIG monitors the continued compliance of a healthcare provider or practitioner with the terms of the CIA. So what is the CIA? It is a legal agreement between the OIG and a healthcare entity or individual whereby the individual or entity agrees to assume specified compliance obligations in exchange for the OIG's agreement not to exclude the entity or individual from participation in Medicare and Medicaid, and for allowing the organization to continue providing services and receiving Medicare and Medicaid payments. While allowing a healthcare provider or practitioner to continue program participation, the CIA is intended to ensure that the integrity of the healthcare program claims and payments process in the future will be protected. And this is accomplished through very specific compliance requirements that are specified in the CIA. While a CIA is usually a part of a federal global settlement, it is exclusively negotiated, executed, and monitored by the OIG. Typically, a CIA imposes specified obligations on a healthcare provider or entity for a 3 to 5 year period. Now let's discuss some of the terms that are used in corporate integrity agreements, just to give you some idea of what is covered by them. First of all, the CIA will usually refer to covered persons, those individuals subject to general compliance training obligations. It will also refer to relevant covered persons, those involved with admissions, referrals, or claim submission, and these individuals will often be required to take much more specific compliance training. CIAs often will refer to the establishment of a disclosure program or a hotline, and to the organization agreeing to undertake regular screening for ineligible individuals by checking the list of entities and individuals subject to exclusion. Again, these are individuals and entities that have been either sanctioned or determined to be not eligible to be participating in Medicare and Medicaid programs. On this list are several other provisions also which are typically included in a CIA. A CIA will require some initial compliance tasks, including the establishment of a compliance program, selection of a compliance officer, adoption of key policies and procedures, and compliance training. The subject entity is required to report on these initial steps in an implementation report, usually between 90 and 120 days after execution, and annually thereafter. Often, a CIA requires the subject organization or individual to retain an independent review organization, or IRO, to conduct specified reviews of the specific areas that are the target or were the target of prior improper activities. These IRO reviews may be required quarterly or annually. In certain cases, the OIG may select a compliance monitor to perform ongoing review of the specified operations of an entity. And in certain cases, the CIA will also require the organization to retain an independent compliance expert to advise the board of directors on compliance issues. So who negotiates the terms of a CIA? Well, typically it is going to be handled by a litigation attorney in the Office of Counsel to the Inspector General. That attorney will usually be very familiar with the subject area and with the type of provider that is involved, such as a hospital, home health agency, hospice, or drug company. As I already mentioned, there will be certain standard provisions which basically are non-negotiable, and then there will be certain customized provisions. The goals of a CIA, from the OIG's perspective at least, are to establish controls in a problematic area, preventing future non-compliance by an entity, requiring the establishment of an effective compliance program, protecting government programs in the future, and perhaps most importantly, protecting beneficiaries. It is important to recognize that the OSIG attorneys that you will be involved with will have different roles and responsibilities. First, you will have your negotiating attorney, which I already referenced, who will both negotiate and assist in the execution of the CIA. The mantle then will turn to a monitor, also within the Office of Counsel to the Inspector General, who will be either an attorney or a paralegal assigned to a particular CIA and assigned to work with the provider to ensure that it is complied with. Now let me turn the microphone over to my colleague, Cornelia.
Thanks, Tom. Well, you may already have gathered from Tom's remarks that just getting to a CIA can be a very lengthy and complicated process involving a lot of different parties. And you usually get to the stage where you are ready to sign the CIA together with your leadership, your attorneys, and then, of course, also by the OIG after a lengthy process. And you may simply want to get done, but just one thing I learned over the years is that there's time before the clock starts ticking, and there's time after. And each has its own considerations. So let's look at what you should think about before you sign off and what you may consider when you negotiate the CIA. First of all, as Tom already alluded to, there are really two types based on our experience, or the most common ones are usually 5 years versus 3 years. And that's a strategic decision you have to make and see what you can negotiate, which ones might work for you better. Well, it's probably a benefit not to have monitors and the government breathing down your neck for many years. On the other hand, the cost of shortening this period might be tremendous. In addition to that, and I get back to what it might entail if you shorten that period to 3 years, you need to really consider what types of external reviewers you are obliged to engage as part of this agreement. There's the IRO, the Independent Review Organization, that's pretty much an auditor. But there's also the monitors that are, how should I phrase this, much more invasive because they're monitoring your operations, and they will be coming by and doing things with you much more frequently on an ongoing basis. So that is a challenge. And then lastly, your board or your governing body may be obliged to engage a compliance expert. So all of these need to be figured out whether you can live with those and what can you negotiate in terms of these three types of external entities that are become part of your corporate integrity obligations. Another issue that you may have to consider are sample sizes. As you may very well know, independent review organizations have to conduct reviews using oftentimes sampling, especially in claims or in arrangement reviews. And there's a pattern there that I just want to share. Typically, when you have annual reviews where the IRO comes at the end of the year, they take maybe a discovery sample of 50 or 100 claims, sometimes more, but they come once a year, and then they write one report, and they do that over the course of 5 years. So they do that 5 times. On the other hand, if you have 3-year CIAs, it's typically combined with quarterly reviews. Well, if you do the math, that's 12 reviews, 12 reports, 12 times the IRO. And while you may have much smaller samples, such as samples of 30, it's a lot of review and a lot of work, and you just have to consider doing a cost-benefit analysis as you go through this exercise, what that might cost. Then you should also be aware of what the differences are in these CIAs. They're generally termed either transactions reviews, and that simply means these are tests for claims accuracy, tests for arrangements accuracy, enrollment accuracy. So these are tests of things, while systems reviews are business process reviews. And CIAs can be structured where you fail certain tests, such as paid claims sample. You may then get to do a systems review. That means the IRO that has to do these reviews comes on site and does further review, business process reviews. So understanding these terms and what triggers what is really key before you sign on the dotted line, and trying to really understand this. Another aspect in these CIAs, oftentimes found in the appendices, is what are the areas of review, such as the universes that define the items that need to be reviewed by an IRO or others. Well, the devil is always in the detail. And it matters whether it says federal health care programs and paid claims for federal health care programs, or Medicare paid claims, or Medicare and Medicaid paid claims. Clearly, if you have federal health care programs in there, it means all have federal health care programs. It's a much more invasive review, and again, that has to be carefully considered. Another aspect that you should consider is whenever there's talk about extrapolation, do you really understand what that means? Do you understand when extrapolation comes about, when it is done, and how it is done? That may be some discussion you may want to have amongst yourselves before you actually sign the CIA. And then this is really something to be aware of, that the folks that, and we find sometimes it's surprising, but oftentimes the guys that sign the CIA are not the ones that have to implement the CIA and live with the agreement. Now, that's just the nature of the beast. But as you sign, especially the entity that is signing, you may want to consider those folks that are affected, especially the billing folks, the contracting folks, your legal department, and have everybody weigh in if they read and interpret the CIA or the draft CIA the same way, and do they understand what it says? So you may want to go beyond just your senior executives that may not really be aware of the details. So it's good to find these things out before. Let me go to a few more considerations. Tom talked about the covered persons and the relevant covered persons. The only thing I want to say here is look in your CIA what it says there, because whoever is covered, that means covered by the CIA, this typically triggers that you have to do some amendment of your policies and procedures, rewrite them, and oftentimes you only have 90 days to do that, or because we'll talk about this in a bit, you have to provide an implementation report. And so think of the definition and how that might all of a sudden age your policies. It's important when you negotiate to make sure that if you have an effective compliance program that may have had some failures, that you still get that acknowledged. Discussion is often around, in the context of reportable events that are part of CIAs, what's a substantial overpayment? Well, I haven't really seen a clear definition, so that's always up for debate, but clearly $5,000 is different for a small physician practice in a hospital system. So some thought should be given to this particular reportable event. And understand that while you're under the CIA, of course, you have to do your own auditing, and you will have to repay some claims that you might find incorrect. But all of that can be handled through your regular administrative billing and refunding. But if you do audits and you find significant issues, that may then become one of these reportable events. So what is what? You need to think about this. The error. Often there is some confusion what errors and ARAs are, especially when it comes to the paid claims reviews by the independent review organizations. And there's different concepts of errors, but typically when we deal with CIAs, it's not the percentage of claims with an error. let's say you have 30 claims and 10 are wrong, then you have 33% error rate. No, what's meant is the percentage of money is in error. So that is a different thing from the occurrence error. We talked about the definition of universe. And again, how is a universe defined? Be it arrangements. Well, what does that mean? What is included if I, let's say, review expenditures? What type of expenditures? If it's marketing expenditures, does it include sales expenditures? Exactly what is what? If I'm doing claims, I already mentioned what type of payers are involved, what type of time frame is involved, how do I define it by payment date, by submission date, date of service. All of these are important questions to ask. Focus arrangements is another one. This deals with contracting review and contract reviews where there might be a STARCO anti-kickback issue. And again, figuring out what type of contracts need to get reviewed is something important to understand. As we move along, I just wanted to make a few comments on the samples and the claims in particular. There's really two types of claims that need to be reviewed, two types of samples that usually are reviewed. The quarterly probe samples that are quite common in more recent CIAs, where every quarter 30 claims are reviewed. And then there's the annual discovery samples that could be 50 or 100 or sometimes even 200 claims. But in all of these, the IRO has to look whether or not this error rate, this percentage of monies in error, and not compliant with the payer guidelines and CMS guidelines, whether that error rate is less than 5%. Now, looking at a paid claim sample of 30 claims and checking whether you are doing better than 5% wrong is a very tough question, and it's a very hard standard. So as you sign this, think about this. And I just want to point out, I've said at the bottom of the page, in the country, we're not doing much better than 10%. So as you are coming out of this long process and ending up with your CIA, are you really there? It should give you pause, and there should be a lot of effort to get the billing correct, because it's a very, very tough standard. Again, reading the CIA carefully as you negotiate whether or not there is extrapolation. In the more recent CIAs where there's quarterly reviews of 30 claims, there's typically no systems review triggered whenever the error rate is above 5%. But that is not so when you have discovery samples and annual reviews. It usually then triggers a systems or business process review. And that means the IRO will come on site and look at your business processes and find root cause analysis of why things went wrong. So that can be costly and time-consuming. So thinking about all of these requirements as you negotiate is really something that needs deep discussion, I'd say, to make sure you know which version of CIA you're getting into, and what are the cost-benefit analysis between 5 years and 3 years. And then I'm saying on this slide as well, how much uncertainty can you stomach? Let's say you're doing everything on 30 claims, and there's usually requirements that when you do this randomly, you have one statistical random drawing. Well, if you have an unlucky draw and you have a big claim that has a problem, then that means you are very easily above your 5%, and that means the percentage of the, let's say you have a 15% error rate. That means you have to give 15% of your money back. Well, that's what happens with these quarterly reviews and 30 claim sample. Maybe you want to reconsider that and go the annual route and do maybe a larger discovery sample and then a full sample to figure out what is really the overpayment. So these are considerations. Also, and that is almost obvious, I don't want to spend too much time, but as you negotiate your CIA, you need to have the subject matter experts in the various areas, depending what the major area of concern are in the CIA. Well, as you negotiate, one objective should definitely be that the whatever the problem was that was the subject of the violation or misconduct is adequately addressed by the current program, your compliance program, the internal controls. You want to make sure that you can demonstrate it won't recur, and that's kind of the purpose as well from the government side, because they want you to move forward with everything in good order, and that you have appropriate safeguards that when you participate as a provider or supplier, that everything is done in the proper form, and that the federal healthcare programs are charged in a proper manner.
Before signing a CIA, okay, there are a couple of things I think it's important for you to be aware of. First, before you actually enter into it and sign the dotted line, the key operations people and your compliance staff should be familiar with the terms and the requirements of the CIA. They're the ones who are going to have to actually take the steps to operationalize it. So it's critical that they be in the process and that they fully understand what will be expected. Secondly, ensuring that all the terms and the conditions in the CIA are clear to everyone, because there is always going to be the opportunity for some ambiguity or for a particular provision to be unclear. So therefore, it really is critical that everyone look at the CIA and make sure they fully understand the terms and the conditions. Inevitably, there will be some ambiguities, which obviously can be ironed out after the fact, but it certainly makes a lot more sense to have things clear up front. And finally, with respect to the actual terms and the conditions of the IRO reviews, you need to be very clear on what the scope of the IRO review is going to be and how it is to be conducted. As Cornelia has already mentioned, there are different types of reviews in terms of sample size and in terms of what is going to be actually surveyed, and it's important that everyone be clear on those issues as well. After signing the CIA, Cornelia?
Well, now the clock starts, and just to share a little episode, not long ago, I got a call from someone and said, well, I got a call from OIG, and, well, they want the report, and can you help? I said, well, what report? You're looking for an IRO? Well, actually, it was the implementation report. So it was clearly a lack of understanding what it really means to live under CIA, and that those first 90 days are very hectic, and a lot of activity has to happen there. So as you sign the CIA, it's now a good idea to think both from a purpose of how do I, as an entity under the CIA, manage my CIA, and who would be a good project planner, who can take that document and turn it into a work plan for us, who can put timelines on this, and milestones, and deliverables, and what do we have to have done by when. The same thing you might want to expect from your IRO, that they give you some idea when they come or when they want something from you, when do they do a test, and make them do a work plan so that everybody knows what's happening. That's really key. Now, the first 90 to 120 days are, as I said, very critical. Typically, what has to happen there is you have implementation activities, and the entity under the CIA has to submit a report to the OIG. So the IRO is not part of this. But during that period, in the 90 or 120 days, you also have to select an IRO. And if you have other external reviewers or entities, such as a compliance expert or monitor, they may also have to be put in place during that period. So the IRO is selected, and you can then ask that IRO, well, give me a proposal or a contract along with, let's say, a business associate agreement, and you can send that off to the OIG. The OIG has, they usually take about a month to look at this, and then if you don't hear, the IRO is approved. So they're not sending you a letter of approval. It's rather the opposite. The OIG will say, I disapprove But you have to get going and find that entity, that company, or that individual that you want to work with to be your IRO and fulfill the corporate integrity obligation for you. So as you then engage your IRO, the IRO may have some questions, because what I've just discussed is that even though there's a lot of thought that goes into the CIA once it's signed, there is oftentimes ambiguities left. So it's a good idea to establish a good relationship with the OIG monitor. That's the individual at the OIG that is assigned to oversee the OIG, and discuss some ambiguities and get clarification. Sometimes even modification, but that's one thing one shouldn't be shy about to ask the monitor. And keep the monitor, of course, informed about any significant changes. Now, some of the changes you need to inform anyway based on the CIA language, but you may just want to let the OIG monitor also know of things that might come up. So that's really your person at the OIG that you can get information from and get clarification from. And think of all the terms in the CIA, and just be mindful of the fact that if you miss deadlines, it's one thing. If you can't make a deadline, it can always happen for whatever reason. By all means, ask formally for an extension. Don't surprise the OIG. They're busy too. They have a lot of CIAs they monitor. So do that, because if you don't and you miss your timelines, the fines start coming up, and they can be severe. It could be $1,000, $2,500 a day, so you don't want to get there. Tom already explained what the IRO is, but in a nutshell, it's the eyes and ears for the OIG while not being an agent of the government. And it's paid by the entity under the CIA, so it's a very interesting role. It's a dual role, but one of the key features of the IRO is really that the IRO must be independent and objective. So it's not really working for the OIG, and it's not really working for the entity. It's really an independent and objective organization or reviewer. And that independence and objectivity is mandated through the CIA, and means you have to comply with what's called Yellow Book standards or GAGAS standards. So sometimes we have to explain that at the beginning, that in simple terms it means the IRO cannot be your typical consultant. And the IRO cannot be somebody you're already comfortable working with. Because if they were, and then they would be reviewing their own work, and that can't be so. That wouldn't be an independent review. So that's important to understand, that it's not a consultant and not an advisor. The only advice they can really give is based on the findings and observations of their reviews, but other than that, they can't do training for you or tell you how to do things. It's really only based on what they find and review. And they have to be qualified. Typically, there are certain certifications that are required if claims reviews are the requirement in the CIA, or they may need to be certain specialists, but you have to be sure you have somebody that has experience and the proper qualifications. What types of reviews are conducted by an IRO? Well, we already talked about the systems reviews. So that would be reviews that are either mandated maybe in the first, third, and last year of the CIA. That means a business process review. They would look at your policies and your procedures and your business practices. That may be in billing. That may be in contracting and marketing. It depends on the CIA. The other types of reviews we could call transactions reviews are really those where they test through samples expenditures, claims, arrangements, and so on. And then in addition to that, there may be also unallowable cost reviews, and that really is often required only in the first year. And unallowable costs, simply stated, are those costs that the healthcare organization incurred due to the CIA. So attorney's fees, costs of getting to the settlement, all these types of costs are really unallowable and need to be separately tracked, and they will be audited by an IRO. I mentioned the independence and objectivity. So as you should be aware of this as you look for an IRO, that they give you a certification along with their agreement, and they should provide that certification before they do reviews. And they should know and have heard what the Yellow Book standards are, because if they don't, they really don't qualify. So make sure you have an objective and independent, well-qualified IRO to do the work. This is just some reference that details it a bit more. I think it's self-explanatory. I don't have to go through that in great detail. Quickly about some other entities, there are independent monitors. These are not IROs. They are selected by the OIG, not the entity, and they are literally monitoring operations and can do a variety of monitoring. They could be quality monitors, and they get into your care management and case management and review that. But they could also be compliance monitor, where they actually look on an ongoing basis what you do in terms of trainings, how you comply with the CIA, what quality assurance processes you have, and so on. So there's ongoing review. They're required to have full access to everything you do. They will come on site periodically, maybe every quarter. They do their own initial baseline assessments, and they prepare their own reports that they will send to you and the OIG.
In some instances, the OIG will require the selection of a compliance expert. This will be either an organization or an individual who is to counsel and provide advice and guidance to the board of directors on either the compliance program or specific compliance responsibilities. Cases where this is required typically may involve a company where the OIG believes that the board of directors is not adequately educated and conversant on compliance issues and needs to have expert assistance in fulfilling their compliance responsibilities. The compliance expert needs to be also impartial, meet with the board on a regular basis, provide assistance to the board on compliance issues and on the compliance program, and often is required to prepare a compliance program effectiveness review report as well.
And just as a comment on this compliance expert role, just remember that oftentimes CIAs require that boards sign a resolution that they are actually stating that everything is in ship shape, the compliance program is working, and everything else is working. And for them to sign that, they may just need to get some extra help, and the CIA mandates that help. I see that actually as a benefit, even though it costs, but I think it can also be very helpful and can make a tremendous difference that the board can do their work appropriately. What to expect from the IRO and when they commence their review? Well, it again depends whether it's a very hectic type of period when it's quarterly or whether it's annually. But first of all, make sure when does the reporting period, which is the years that the time period from the effective date of the CIA in the first year, when that is, and what are the periods for the quarters if there's quarterly review. So make sure all the dates are understood. But once that is clear, then what might happen in the first quarter or during the year? Well, there may be some preliminary testing, whether the data can be extracted. There may be some document requests, maybe about the business process or software applications. Ultimately, the IRO may just want to understand your business and get ready, but understand the audit and how it works and the protocols. That does not happen. That's not shared. But it's just getting ready to do the work once the clock starts ticking for the reviews. And the time frame for these reviews are very short, usually 60 days. so it's important to have everything ready. There will be draft reports written that are shared, or preliminary draft results that are shared. Because the IRO works under GAGAS, there has to be a fact-finding, and there should be some sort of entrance and exit type conference to make sure everything is understood. And then as an entity, you should have the opportunity to give feedback on the draft. And if the final report is still in disagreement, of course, you can attach your disagreement or your own comments or resolutions or corrections that you already have made along and send that along with the final report to the YG. Supplemental material request is another thing I want to quickly point out. This is allowed, especially when there is claims reviews. You have document requests, and you may, the IRO may go back and ask for maybe some particular case there. It looks like something is missing or was forgotten. But do not misunderstand this as a process. Okay, well, over 60 days, we're going back and forth, and piecemeal information is fit. It should be, if ideally, one request, and then everything is submitted. And then on occasion, there will be supplemental requests. So it is not an ongoing back and forth. And it's important for those that put the materials together, whether it's supporting arrangement reviews or claims reviews, that you know exactly what was given, and you have the copy in your office and can compare. So that is really something that needs to be organized and project managed by the entity, and of course by the IRO. So a good IRO sends you a formal request, and possibly also requests where you can check off what was given, so that in case there is anything that's missed or lost during this process, there is kind of a checklist what was supposedly given. Also ensure that on the healthcare entity side, it's clear who the person is. The IRO can always speak with, and they have a contact person at all times, and also understand who is the contact person at the IRO, and possibly the backup. But that should be established very clearly. And to make sure everything is properly done, everybody should be aware of certain types of certifications the IRO will likely ask the healthcare entity for certain types of certifications, that the data they provided were complete and accurate. At the same time, the healthcare organization has the right to get and must ask the IRO for certification of independence and objectivity. So Tom and I are almost at the end, but I think Tom always emphasizes that it's really important to explain to your staff on the healthcare entity side the role of the IRO. It's not your run-of-the-mill, and that's not meant in a bad way, but it's not your typical consultant, and it's not your typical reviewer. It's a certain type of reviewer that's much more formal, and they need to understand the purpose and work with the IRO. Get your certifications and understand the objectivity and independence requirements. Well, it's not a bad idea to replicate and try to do what the IRO would do, so that you get an idea what's ahead for you and what might be the outcome of these reviews. So that's not a bad thing to think about. Sometimes I'm asked, well, we're doing auditing and monitoring, and we should have a good compliance program. We're doing so much reviewing, and you're the IRO. Do we have to do anything else, or can we just count that as our auditing and monitoring? Well, my suggestion is try to do a little bit internally, aside from what the IRO does. Don't rely just on the IRO to find out things. Start planning from the day one for your annual report that is due. It has to be prepared by the healthcare entity after the reporting period, meaning that first year is over. So to do that well, you have about 60 days. That's the clock then, that starts for the report. When that report is due, it's 60 days after the end of the reporting period. But start planning writing that report day one, meaning over the course of the year, read your CIA, look at all the things that you need to cover in that report and what you need to write about. Don't be shy to educate your IRO and explain your business. Believe me, we've seen a lot of different organizations. Everybody is different. Everybody is unique. There's always a little twist. Explain yourself. Don't be shy about that. Be prepared to get all kinds of data requests and the need to assemble data, get on the healthcare entity side. Your team ready to do this in short order. Do you know how long it takes you to pull one chart or one claim or the arrangements? Maybe it takes longer than you think. There's a few other things I just want to, and the list is sort of explanatory, but I just want to say, make sure that if you have any kind of corrective actions based on IRO reports, that whatever you do before you send in your own reports, mention that, explain them so that correction is already taken, or explain what you will be doing to fix any gaps. And keep planning. I think that's really one of the best lessons learned that we can share. If you plan from day one, it will be much more smooth. It will be less of a headache and less of a mad rush. And no matter what you will do, it will be hard. It is more work than you ever thought, but it is very doable with a little bit of planning and keeping spirits up. And with that, I pass it back to our organizers.
Okay, great. This is Lynn. Thank you very much. I'm going to take just a quick minute or two to highlight our ComplyTrack product and how it can be utilized in conjunction with some of the requirements that we've been talking about today during this webinar. I do just want to remind everybody that if you have any questions, we will have a few minutes at the end. You can use the Q&A option on your menu bar to submit those questions to us. So what I want to do quickly is just talk about a couple modules of ComplyTrack that you're going to be able to utilize. And the first of those that I want to highlight is our Activity and Event Manager. And this is a tracking tool. It's designed to assist organizations in tracking all of the things that you do and deal with on a daily basis. So those could be issues or incidents, but also the things that you're doing periodically, education with staff, auditing and monitoring activities when meetings are being held. And that's going to fit very nicely into some of the requirements. We just heard a second ago the importance of doing some of your own internal auditing and not relying exclusively on your independent review organization. The importance of training your staff, training your all of the covered persons on your policies and procedures and the things that you're doing as part of your independent, as part of your corporate integrity agreement. And all of that can be managed within the Activity and Event Manager, and it gives you one place where all of this information is being maintained, where it's accessible to those who need it, and it's going to be quick and easy for you to generate an extensive amount of reporting on everything you're conducting within the system. It gives you the ability to tie together all supporting information, so that could be the PowerPoint you used for the education session, the roster of attendees, the agenda that you utilize, signed attendance sheets. That could be work papers from an audit that you're doing internally, a report of findings if you're using this to capture your communications with your independent review organization, being able to maintain a log of that. Setting up email reminders, the importance of not missing any deadlines and being able to have reminders set up so that as things are coming due and deadlines are approaching, that the appropriate individuals can be alerted to that. So certainly having the ability to use this in conjunction with your CIA, but also being able to use it in just your day-to-day activity management, issue management. I also want to highlight the fact that we have a document manager, a place where you can create, manage the approval process for, and maintain over time all of the different types of documents that your organization works with. And talking primarily here about using it with policies and procedures. You may need to develop or revise policies and procedures regarding your corporate integrity agreement. So having a place where you can create the policy, it's going to automate the review process, so all of the individuals that need to review and comment and sign off on that document, that can be done through our application. And there's also a companion publishing site, so being able to take the policies and procedures that you've built in here and making them available to your employee population as necessary. There is a survey manager, and the survey manager gives you the ability to create surveys on anything you want that you could send out to as many individuals as you might need to for response. So for example, in your corporate integrity agreement, there may be a requirement to distribute your code of conduct to covered persons. So you could do that within the application. There's the ability to attach documents or links to documents within the surveys you send out. You can include an attestation question, have individuals attest to the fact that they've received and read the document. So in this general policy example I have, you can see in the third question I've got my policy attached, and then my fourth question is my attestation question. And then you might want to add in additional follow-up questions related to the document you sent them. You can use this for a compliance program effectiveness survey to make sure that the compliance program you have in place, the important elements of it, the fact that there's a hotline, that your employees know who your compliance officer is, for example. You could send out a survey. And then I also just want to quickly manage the fact that we have a risk assessment manager where we're providing pre-developed question sets that you can utilize to do your own internal risk assessment. And we have content related to the OIG work plan project areas. We have content related to Medicare conditions of participation. We're addressing high-risk compliance areas like anti-kickback and STARK and EMTALA and community benefit and other Form 990 issues and things of that nature. But then there's also a library of content specific to the OIG compliance program guidance requirements. So having a tool that you can utilize to assess your compliance program and make sure that it contains what it needs to contain to be considered effective by the government. Content that you can use to be proactive in your compliance efforts and see where issues exist and where you need to develop policies and where you should be doing education with staff, for example. So those are just a couple pieces of the system in my quick 5 minutes that I wanted to highlight. So at this point, we have a few minutes left to take questions. So I am going to turn this back over to Kelly Price and see, Kelly, do we have any questions at this point?
Yes, we do. Actually, we have quite a few questions, and we are kind of butting up against our end time. So if we don't get to your questions this afternoon, we will reply to you via email, so you will get an answer there. We do. The first question I'm going to throw out, and I'll just throw it out to Cornelia and Tom. It's coming from Debbie, and Debbie's asking, who determines whether 3 or 5 years time frame? I thought OIG would dictate that.
Well, it is ultimately OIG that will make that determination. However, there will be situations are where a 3-year is preferable to both the OIG and to the party being under the IRO reviews. So I think the parties need to have a discussion. Is it better to have quarterly reviews with regular reporting or an annual review? It's a function partially of the wrongdoing, of identifying early on whether the practices are being remediated and whether or not both the government will be protected as well as the entity from a 3 to 5 years. So it is a negotiable issue.
Great. Thank you, Tom. Next question is coming from Donald, and he is asking, I understand that unallowable costs are not permitted on a cost report if a CIA is in place. Are legal fees that are not part of a government investigation, no CIA in place, allowed on a cost report?
Well, legal fees, if they're tied to the CIA and everything around the CIA, they wouldn't be allowed.
That's correct. The settlement typically that the Department of Justice negotiated specifically states that legal fees associated with the negotiation of any kind of settlement or investigation of the case is not to be considered an unallowable cost. And it cannot be put on a cost report, and the IRO is to evaluate whether or not those allegedly improper costs have been put on the cost report. So if it's something to do with normal business operations of an entity, let's say a hospital, then to the extent that CMS approves those type of expenses, they can be put on a cost report.
I mean, the question is, what if there's other investigations or other demand letters, and you may have legal fees, but they're not directly tied to the CIA.
Right.
So I don't know whether that was the question.
Okay, great. Thank you. Next question is coming from James, and James is asking, have you had any success in getting the OIG to acknowledge the serious limitations on using a 30-claim discovery sample in a setting where the payment for each line item can vary widely and that produces a high error rate based on just 1 or 2 overpaid claims?
Well, we can't really disclose what we do in detail on these different CIAs, but I can just share in general that we had discussions with the OIG, and that from a statistical perspective, I can just tell you that a 30-claim sample is a challenge, simply because there will be a lot of uncertainty remaining, especially if you extrapolate from that. So I want to leave it at that.
Okay, great. Next question we have here, and I believe, Cornelia, you may have addressed this earlier when you're going over the tips, but it's coming from Sharon, and she's asking, is it wise to do internal mock testing or auditing to see if there is any weaknesses?
I think it's, Tom, you may disagree, but I think it's wise. First of all, with an effective compliance program, you have to do auditing and monitoring, so you got to do that anyway. And it's better to know and prepare and fix and do that early on, so that you don't have to return hard-earned money, that you just fix the errors yourself. And that's what the OIG wants as well. They want you to do your work, have an effective compliance program, and the way to find out is periodically audit yourself. And if you mock audit and play internal IRO even better, then you really get an idea of what's going on.
Okay. And our last question, I can't make out the name, but I'll read it. They're asking, did I miss remarks on settlement versus CIA?
Settlement versus CIA. Well, a settlement is typically a global settlement of all of the government's allegations. A CIA is one remedy or result of that settlement. A settlement may result in a plea agreement. On the criminal side, it may result in a False Claims Act monetary payment. And the CIA is what the OIG will enter into to allow an entity to continue participating in the programs. In exchange for that continued participation, the OIG through a CIA will require very specific compliance obligations imposed on an entity.
Okay, great. And I'll go ahead. I'm sorry.
And I mean, for purpose of the IRO, at least, the only reason we would look at settlements is for unallowable costs, because they're oftentimes defined in settlement agreements. But for practical purposes in the healthcare organization, once the CIA is signed, this is really what guides you going forward and what you have to worry about.
Great. Thanks very much. That's all the questions that have been submitted. Thanks very much, Cornelia and Tom, for speaking today. And for those of you on the call today who may be attending the Compliance Institute Conference in Orlando, I'd like to extend an invitation for you to come by the Wolters Kluwer exhibit booth number 613 in the vendor area. Thanks again for joining us today. I hope you have a great rest of the day as this concludes our presentation.